August 14th, 1889. 7:10 in the morning. A dining room at a railway station in Lathrop, California. A woman named Sarah Althea Hill leaves the room to fetch her handbag from a train. In her absence, her husband, the former Chief Justice of the California Supreme Court, walks up behind a United States Supreme Court justice at a breakfast table and slaps him across the face. The justice's bodyguard rises and puts a bullet through her husband's heart at point-blank range. She was not the only one. Before her, an orphaned New Orleans woman spent 57 years filing suits over a father who never named her. A teenage girl in England beat 200 rival claimants to a $4 million San Francisco fortune. A school principal produced pencil-written marriage contracts against a silver king and died in an asylum in Iowa. 4 women, 4 papers, 4 of the richest men in America. Which of the papers was real? If tonight's story pulls you in the way these stories pull me in, tap subscribe. This channel goes deep on the women of the Gilded Age who fought the men who tried to make them disappear. And there is a lot more of it coming. Chapter 1. A woman legally did not exist. Under the common law that ruled every American courtroom in 1834, a married woman had no name of her own, could not sign a contract, and could not sue in her own right. She existed inside her husband, in the phrase that lawyers had used for 6 centuries. The doctrine had a name. It was called coverture, and it meant, in strict practice, that from the moment of the wedding, she and the man who married her were, in the eyes of the law, one person. That person was him. She could not, on her own, sell a piece of land she had inherited from her father. She could not open a bank account in her own name. She could not enter into a business partnership. She could not sign a will that disposed of her own property without his consent. She could not testify against him in court. In many states, she could not testify at all. If a stranger owed her money, her husband was the one who sued to recover it. If a creditor came for her jewelry, her husband was the one they served the papers on. She was, on the record, a person suspended inside another person, and that other person was the one whose signature was worth anything. There was one thing coverture had not swallowed. She could still, in theory, own her own name. She could still, in theory, be married or not married, be a wife or not a wife. And in a country that was still, in the middle of the 19th century, deciding what marriage even was, the question of whether a particular woman was in fact anyone's wife could turn on very little indeed. On a signature, on a letter, on the memory of a witness, on a paper. The paper is the object at the center of this whole story. 4 women, 4 papers, 4 of the richest men in America, and an entire legal system that had told each of these women, in one way or another, that she legally did not exist. The reform came slowly, state by state, picking up speed after New York's landmark Married Women's Property Act of 1848. The legislatures of the United States began to peel coverture back. A married woman could hold property inherited from her father. A married woman could sign a contract for her own trade or business. By 1848, more federal courts practicing the common law were adopting the reforms. By the 1880s, most states had chipped the doctrine down to a shape a modern lawyer would recognize. But the reform did not run everywhere at once. It did not run at the same speed in Louisiana, whose civil law had never used coverture in the English form. It did not run at the same speed in California, whose civil code of 1872 would leave a gap that mattered enormously for one of the 4 women in tonight's story. And it did not run at all before 1834, which was the year a woman in a Philadelphia parlor stood up from a stack of letters, read her own name in her father's handwriting for the first time, and understood that the man who had raised her had lied to her about who she was for a quarter of a century. The California Code, when it finally came, did something odd. The California Civil Code of 1872 allowed a marriage to be created by a written declaration signed by both parties. No church, no priest, no witnesses required, no public notice. 2 signatures on a piece of paper. That was enough, in the state of California, to make a woman a wife. 20 other American jurisdictions had some form of common law marriage that recognized couples who had held themselves out as married. But California had gone further. California had said, in statute, that the paper alone was the marriage. This is the doctrine on which Sarah Althea Hill's whole case turned. And this is the doctrine that Nettie R. Craven, a San Francisco school principal, would test against the estate of a Bonanza Silver King with 4 contracts written in pencil. The Louisiana Civil Code of 1825, based on the French and Spanish traditions that had ruled New Orleans before the purchase, did not use coverture. A married woman in New Orleans in the 1830s had more legal room than a married woman in New York, but she had less than she needed. Because the executor system that governed the estates of dead men in Louisiana and the property machinery that turned Canal Street from a swamp into a fortune worked on paper too, on wills, on deeds, on the signatures of the 2 men who happened to have been named executors in a rich man's last testament. If those 2 men decided that a girl had not been born to their friend's marriage, and if they had a will in their hands that said the same, the girl was on her own. Section 1664 of the California Civil Code, added later in the century, was the 3rd doctrine that mattered. It let anyone who thought they were the heir of a dead person bring a proceeding to be adjudged the heir. Combined with sections 230 and 1387 on adoption by recognition and institution as heir, Section 1664 opened the door for 200 rival claimants to a Welsh-born San Francisco capitalist's $4 million estate to file appearances at the same time in the same probate court, and for a teenage girl in England to beat them all. 4 legal doctrines, 4 papers, 4 women, 4 rich men. The pattern is not a coincidence. The pattern is what happens when a legal system that will not let a woman own herself is asked, again and again, to let a woman own a fortune. The paper is what she has. The paper is what she can produce. The paper is what a judge can look at. And the paper is, almost always, less than she needs. Tonight's story goes in the order these women paid for it. First, the woman who paid in time. 57 years of paperwork, 2 dead husbands, a verdict that came down 6 years after her funeral. Second, the girl who paid in proxies, a childhood in England, while adults fought her war for her over an ocean. Third, the woman who paid in reputation, a professional life in San Francisco reduced to a paragraph in an Iowa death notice. And fourth, the woman who paid in everything, a husband dead on a dining room floor with a hole through his heart, a Supreme Court justice 5 feet away at a breakfast table, 45 years locked inside the California asylum at Stockton. The frame of the whole story is the first of them. Her name was Myra Clark Gaines, and the moment her life changed happened in Philadelphia in the year 1830, when she found a letter in a stack of her guardian's papers and read a name in it that she had never seen before. It was her own. Chapter 2. The Letters in a Philadelphia Parlor. In 1830, in a stack of correspondence in Colonel Samuel Davis's papers in Philadelphia, a 25-year-old woman named Myra found her real name and learned that she had lived a quarter century as somebody else. She had come to the letters by accident, most probably, though the accounts differ. She had come looking for one thing and found another. And what she found when she pieced it together across an afternoon and an evening and a night, was that the man she thought was her father had raised her under a false name and had lied to her for as long as she had been alive. Her real father, according to the letters, was named Daniel Clark. He had been Irish-born, and he had come to Louisiana in 1787 at the age of 20 on the invitation of his uncle, who ran a mercantile house in New Orleans. He had prospered in the city almost immediately. He had run the uncle's business, invested the profits in New Orleans real estate, and by the turn of the 19th century had accumulated a fortune that made him one of the richest men in the territory. He had held political office. He had been appointed by Thomas Jefferson as the United States Vice Consul to New Orleans in 1801. He had sought the governorship of Louisiana and had been unsuccessful in obtaining the appointment. And at the height of his powers, around 1802, he had begun a relationship with a young woman named Zulime Carrière. Carrière had been a French Creole beauty from a modest background. She had been married at 13 to a Frenchman named Jérôme de Grange, who at 40 had described himself as a wealthy nobleman. The marriage had turned quickly bad. By the time she met Daniel Clark, de Grange was a business associate of his, and Zulime was already looking for a way out of what her later lawyers would argue had been a bigamous marriage from its beginning. Ecclesiastical records would eventually show that de Grange was arrested and condemned for bigamy. With wives in Europe, he had not disclosed. Whether Zulime herself believed him a bigamist at the time was less clear. Her later court testimony was contradictory on the point. But the two important facts, if you were building a case 50 years later, were that des Grange's marriage to her had been argued as void, and that Clark and Carrière had, on Myra's side of the case, secretly married one another before her daughter's birth. The marriage was secret for two reasons. The first was Carrière's tangled first marriage. The second was Clark's political ambition. A publicly acknowledged marriage to a French Creole woman with a doubtful earlier husband and a modest family behind her would have cost him the governorship he was still trying to win. So the marriage stayed quiet. When Myra was born on the 5th of June 1805 in New Orleans, her paternity was not proclaimed. When she was an infant, Clark broke with Carrière, courted a socialite named Louisa Caton, whose grandfather, Charles Carroll, had signed the Declaration of Independence, and by the account preserved in Myra's later suits, destroyed every document that could have proved the marriage to Zulime. Myra was handed to Clark's close friend, Colonel Samuel Davis, and his wife Marion, and raised as their daughter under the surname Davis. She was told nothing. Clark visited her as a child, contributed to her upkeep, and never publicly named her. He died on the 16th of August, 1813, when she was 8 years old. The Davises, when the War of 1812 reached Louisiana, moved north with Myra to Philadelphia. She grew up in the city as a Davis, in a Davis household, with Davis siblings, and the truth of her origins was never spoken aloud in her hearing. She was educated, sheltered, socially placed. She was, by every appearance, a young Philadelphia woman of a comfortable family. Then, in the spring of 1830, at the age of 25, she found the letters. The letters were correspondence from Daniel Clark to Samuel Davis. They referred to her as Clark's daughter. They discussed her upkeep, her education, her future. They named her mother. They named the city she had been born in. They referred to her by the surname Clark, not Davis. She read them, understood them, and put them down. And then, according to what her later biographer Elizabeth Urban Alexander reconstructed from the case papers and her own correspondence, she went to Colonel Davis and asked him whether it was true. He confirmed it. She had been born in New Orleans to a man named Daniel Clark and a woman named Zulime Carrière. Her father had been one of the richest men in the territory. He was dead. His estate had gone to his mother by a will he had made in 1811. He had made a second will in 1813, days before his death, that named Myra as his legitimate daughter and left almost everything to her. The second will had never been found. The men who had been his executors, Richard Relf and Beverly Chew, had denied its existence for 17 years. Myra did nothing at first. She was a quarter of a century into a life that had just been revealed as another woman's. She had no legal standing to sue in her own right. She had no money. She had no lawyer. She did not know New Orleans. She did not speak French, which the courts of Louisiana still relied on heavily. She was a woman in Philadelphia, with a stack of letters and a name she had never been called. 2 years later, she married. His name was William Wallace Whitney, and he was a young lawyer from Binghamton, New York, who had come to Philadelphia looking for practice. He was 27, ambitious, and, on the account of everyone who knew him, in love with her. She told him what she had found in the letters. He asked her what she wanted to do about it. She told him she wanted to be recognized as her father's daughter, and she wanted his estate. He said he would file. Because married women in America in 1832 had no legal standing before the federal courts, the suit would have to run in his name, with her along as etiuix, the Latin phrase for "and wife." He would be the plaintiff of record. She would be, in the caption of the case, the wife along for the ride. This is what coverture meant in practice. A woman with a fortune to claim had to borrow a man's identity to claim it. On the 18th of June, 1834, Whitney filed in the Court of Probates of New Orleans. The suit was called W. Whitney v. Eleanor O'Byrne et al. It asked the court to declare Myra the true heir of Daniel Clark under the missing 1813 will, and to order Relf and Chew to transfer to her every asset of the estate. Named as defendants were Eleanor O'Byrne, the daughter of Clark's mother, Mary Clark, under the 1811 will, along with Relf and Chew themselves. In the years that followed, the couple would widen the roster of named defendants to at least 25, adding purchasers who had bought pieces of Clark's estate from Relf and Chew over the 20 years since his death. Their case, in effect, threatened title to plantations across Louisiana, to hundreds of enslaved people held by those plantations, to bank stocks, to rents, to bank deposits, to city lots in the New Orleans business district, and to the ground under what was becoming Canal Street. The New Orleans papers, in the beginning, were with Relf and Chew. The New Orleans papers were of the city, and the city's leading citizens had bought their houses and their bank stocks from Relf and Chew's ledgers. Northern papers, in Philadelphia and New York, took her side. They cast her as an injured orphan. A romance published under the title Myra, the Child of Adoption. A romance in real life ran serially in the northern press. She was called plucky, brave, wronged. Her lawyers, who eventually included Daniel Webster and Francis Scott Key and John Archibald Campbell and Reverdy Johnson, would echo the romance framing in their arguments before the Supreme Court. But the framing was not what she chose. The framing was what a young woman with a paper and no political power in New Orleans had to accept in order to be heard at all. The letters in the parlor were the first paper. She had held them, and she had understood them, and she had been unable to unread them. The parlor lamp had shown her a name she had lived 25 years without knowing was hers. Every other piece of paper in her life for the next 53 years would be measured against those letters. The missing 1813 will was a paper she had never held. It had been described to her by witnesses who had seen it, and by her father's friends who had heard him read it, and by the nurse who had cared for her as an infant and had been in the room when Clark signed it. The nurse's name was Harriet Harper Smythe. She would testify at Myra's trials. Colonel Joseph Belchas, one of Clark's closest friends, would testify that Clark had told him Myra was his legitimate daughter and heir. But the paper itself, the 1813 will, was gone. On Myra's account, and on the testimony of two of the men closest to her father, Ralph and Chew had destroyed it in the hours after Clark's death. She was 29 when the first suit was filed. The next 57 years of her life would have one subject, and one only, and she would not live to see the ruling that gave her heirs the money. Chapter 3. The Husbands Who Died in Her War. 2 husbands buried, 2 fortunes gone, and by 1849 she was still the plaintiff. Whitney had died first. It happened in New Orleans, in the yellow fever epidemic of 1837, 3 years into the case. He had gone down to the city to press an argument, contracted the fever, and died in 3 days. He was 32 years old. His personal fortune, all of it made through his New York law practice before the case had opened, had gone into her suits. She was 32. She had been married 5 years. She was a widow in Philadelphia, in the middle of the largest civil lawsuit in the history of the United States, with a case that could not be filed in her name, and no husband to file it for her. The case did not stop. She hired new counsel. She traveled to New Orleans and back to Philadelphia and back. She wrote to Colonel Davis, whose sympathy for her project had frayed almost from the beginning of her marriage to Whitney, and whose relationship with her cooled into the correspondence in which she referred to him only as the Colonel. She endured the year Ralph and Chew filed a libel suit against Whitney in the last months before his fever, and had him convicted of criminal libel and imprisoned for 1 month. She endured the Louisiana Federal District Judge's refusal to hear her petitions in equity, a jurisdictional trap that added decades to the case. She endured the losing preliminary judgment of December 1834, which had gone against them within months of Whitney's first filing. 2 years after Whitney died, she met a general. His name was Edmund Pendleton Gaines. He was 52. He was the hero of Fort Erie from the War of 1812. He had been decorated for bravery by several state legislatures. He held a major generalship in the United States Army. He had lost his first wife. He met Myra in 1839 at the age of 52, courted her, married her, and pledged in the correspondence they exchanged before the wedding that he would take up the fight for her father's estate as if it were his own. He was, at the moment he made that pledge, 34 years her senior. He had money. He had reputation. He had a general's pension and a fortune of his own from investments in Western land. He put all of it into her suits. The marriage was national news. In the year that followed, the papers of New York and Philadelphia and St. Louis and Cincinnati carried columns on the courtship and the wedding as if it had been a royal match. In 1840, a year after the wedding, the general took her on a lecture tour of the Atlantic states. He was campaigning for a plan of national defense that promoted floating batteries over steam warships. He spoke first, in packed halls, to chambers of commerce and militia companies and public assemblies. Then he introduced his wife. She rose. She spoke to the room. She spoke about the horrors of war, and she spoke about the case, and she spoke about her father, and she spoke about the fact that she had lived a quarter century under the wrong name. She spoke in St. Louis and Cincinnati and New York and Baltimore and Philadelphia. Women in the 1840s, in the halls of American commerce, were not taken seriously as public speakers. They were not considered rational orators. They were considered ornaments. She stood at the front of each hall and made her case anyway. The halls listened. The papers, on the day after each speech, wrote it up. She was, by the end of the tour, the most famous plaintiff in the United States. In 1843, in a Louisiana district court, she got her first victory in the case. The suit was Barnes versus Gaines. Her alleged half-sister, Caroline Barnes, one of the claimants against Clark's estate, had brought a suit to reclaim a piece of land Myra held under the estate. Myra's lawyer walked out of the courtroom in the middle of trial after an argument with the judge. She was left alone at the plaintiff's table, without counsel, in a court that had never seated a woman as her own attorney. She rose. She addressed the jury. She argued her own case. She had spent a decade on the papers of Daniel Clark's estate. She knew every deed, every witness's testimony, every discrepancy in the executor's accounts. She won. The judge, in the face of the public attention on the case, refused to grant a new trial. It was the first Gaines victory in the record. The following years alternated wins and losses in the Louisiana courts and in the United States Supreme Court. She appeared before the Supreme Court in 1839, in Ex parte Whitney, seeking a writ of mandamus to force the Louisiana Federal District Judge to hear her petition in equity. Justice Joseph Story delivered the opinion. The court granted her the writ. She had, at the age of 34, become the first married woman to appear as a named party in her own federal case in the memory of the Supreme Court bar. In 1848, in Patterson versus Gaines, the Supreme Court held that she was Clark's legitimate child and heir under Louisiana civil law, and that Relf and Chew had exceeded their authority as executors in selling any portion of the estate. Justice James Wayne wrote the opinion. It was the high watermark of her case in her lifetime. It stood for 4 years. In 1852, in Gaines versus Relf and Chew, the court reversed itself on new evidence disputing her parents' marriage. She lost again. In 1849, General Gaines died. He had, like Whitney, poured his fortune into her suits. He left her a widow twice, at 44, with the case still running and no husband in front of her to hold the plaintiff's chair. She never remarried. She would live another 36 years and file every one of them. From that point on, she filed under her own name. The Married Women's Property Acts, which had been passed in more states in the 1840s and were spreading through the federal common law courts, had begun to open the door. She walked through it. Myra Clark Gaines, plaintiff, appears in the case captions of the Supreme Court from 1852 forward. She is no longer et ux, she is the party. The captions are the record of Coverture's slow surrender, and her name in them is a small part of that surrender's history. The Louisiana Supreme Court, in 1858, admitted Daniel Clark's 1813 will to probate. The lost will had been reconstructed from witness testimony and admitted as if the paper itself were in the court's hand. It was one of the great equitable rulings in American probate. In 1860, and again in 1867, the Supreme Court of the United States declared her to be the legitimate child and only heir of Daniel Clark. By 1867, the reported value of the properties her claims touched at their maximum. The properties Relf and Chew had sold in the 23 years after her father's death ran to $35 million in New Orleans real estate. She controlled almost none of them. Each purchaser held out. Each purchaser demanded that his own title be litigated separately. Each fresh piece of the estate had to be forced out of the ledgers of the men who now held it, one deed at a time, before a jury in a New Orleans courtroom. The city of New Orleans itself, which had bought portions of Clark's Canal Street holdings after Relf and Chew had sold them, was the hardest defendant of all. The city refused. The city appealed. The city sent the case back to the Supreme Court over and over again. In 1873, the court ruled for the city in one contested piece of the litigation. In 1876, the court ruled for her in another. In 1881, the court ruled against her in yet another. By the time she was 78, in 1883, she had appeared before the Supreme Court 17 times and the Louisiana state and federal courts at least 70 times. She had outlived Daniel Webster, who had argued for her. She had outlived John Archibald Campbell. She had outlived Francis Scott Key. She had outlived General Gaines by 36 years. She was still filing. There is a portrait of her, taken in her old age, held today in the collection of the Smithsonian's National Portrait Gallery. She sits in a black bombazine dress, her hair drawn back, her face at rest, but not soft. She looks like a woman who has spent 50 years listening to lawyers explain to her why her father's paper cannot be found. She looks, in the photograph, exactly like what she was. She was the plaintiff. Chapter 4. She died 6 years before the ruling. On the 9th of January 1885, at 79, she died in New Orleans of pneumonia and lung congestion. The New York Times, which had covered her case for 4 decades, ran the headline the following morning. The headline read, "Myra Clark Gaines dead. The plucky woman prostrated by pneumonia." The article inside noted correctly that her case was still pending. It noted correctly that the city of New Orleans was still resisting the judgments already entered against it. It noted correctly that she had never seen the money. She had spent 51 years of her life as the plaintiff in the case of the estate of Daniel Clark. She had been married twice and widowed twice. She had raised her children on borrowed money. She had traveled between New Orleans and Philadelphia and Washington so many times that the case papers list her residence in some filings as merely of the United States. She had never remarried after General Gaines died. She had never taken any employment that paid her a wage. Everything she did, from 1834 until the morning she died, had been the case. The final ruling came on the 23rd of February, 1891. The suit was City of New Orleans versus Whitney, William Wallace Whitney, by then being the name of the administrator of her estate. The Supreme Court ordered the City of New Orleans to pay her estate $923,788. A separate ruling in 1889, in City of New Orleans versus Christmas, had already ordered the city to pay her estate $576,707.92 in a related judgment. Her heirs did not receive most of it. The creditors filed first. Attorney fees for the lawyers she had employed across 5 decades, some of them by then in the hands of their own executors. Loans she had taken to keep the case open in the years after the general died and before the reversals had begun to run in her favor. Filing fees, publication costs, reproductions of witness depositions, travel to Washington to argue before the Supreme Court 17 times. Legal expenses and debts prior to the final decree consumed at least $860,000 of the settlement. The heirs, when the accounting closed, received a small fraction of the original judgment. The fortune that had been $35 million in reported value at the case's high watermark shrank in her heirs' hands to sums she would have called, before the case began, entirely ordinary. It was not the money. It had never been the money. It had been the paper. And the paper had said her name, and now the paper was in the record, and the record could not be undone. She had lost the money, and she had won the name. The paper she had chased for 51 years had never been in her own hands. The 1813 will of Daniel Clark, in which he had named her his legitimate daughter and heir, had been described only by the people who had seen it. The nurse, Harriet Harper Smythe, who had been in the room when Clark signed it a month before his death, had told the court what she had watched him write. Colonel Joseph Belachas, Clark's friend, had told the court what he had heard Clark read aloud. Other witnesses had contributed to the reconstruction. In 1858, the Louisiana Supreme Court had admitted the reconstructed will to probate as if the physical document were in the court's hand. That was, in the arc of the case, the moment the paper reappeared. It reappeared as testimony. It reappeared as a court's finding of fact. It reappeared as an entry in the probate rolls of the Court of Probates of New Orleans, 70 years after Daniel Clark's death, that the will had existed and that Myra Clark Gaines had been its principal beneficiary. The archive she left behind is preserved today at the Howard Tilton Memorial Library at Tulane University in New Orleans and at the Historic New Orleans Collection. Her case letters, her personal correspondence, the newspaper clippings she saved from every stage of the case, the photographs she sat for at the height of her fame, the letters from Daniel Webster and from John Archibald Campbell and from Francis Scott Key and from Reverdy Johnson. All of it is in those two collections. The most complete modern biography of her, Elizabeth Urban Alexander's Notorious Woman, the celebrated case of Myra Clark Gaines, published by the Louisiana State University Press in 2001, was nominated for a National Book Award before it hit the shelves. The paper she had chased outlived her by 6 years, and by every generation of lawyer she had employed. Her heirs, standing in the New Orleans courthouse in 1891 when the final judgment was read, received on her behalf a decree that used her name as its principal noun. The city was ordered to pay her estate, not Whitney's estate, not Gaines's estate, her estate. 57 years earlier, in 1834, when the case had opened, the caption had read W. Whitney v. Eleanor O'Byrne, et al. She had ridden into the case on her husband's name. She had ridden out of it 6 years after she was buried, on her own. She died in a small house in New Orleans, in the presence of her family. The obituary the Times ran the next morning was 2 columns long. Every serious American paper ran an account of her life. The lecture tour of 1840 was recalled. The Barnes verdict of 1843 was recalled. The Patterson victory of 1848 was recalled. The 17 appearances before the Supreme Court were recalled. The $35 million in claimed property was recalled. The 2 husbands were recalled. The single black bombazine dress she had worn in her last years to the courthouse was described in the caption of the portrait that ran with her New York Times notice the following week. She had died before the ruling in her favor came down. She would not be the only one in tonight's story to die before the case reached its end. But she was the one whose case had run longest, and she was the one whose death had come closest to the finish. 6 years. 6 years. And the court would rule for her estate. 6 years, and the city would pay. 6 years, and the paper she had been chasing since 1830 would be, at last, a court's finding of fact. The next case in tonight's story would go the other way. It would not run for 57 years. It would run for 7. It would not involve a plaintiff who could take the stand. It would involve a plaintiff who was, in the year the case opened, 10 years old and living in England. It would not turn on a missing will. It would turn on the absence of any will at all. It would not involve one executor's fraud against one child. It would involve almost 200 rival claimants, each holding a piece of paper against a dead man's $4 million estate. And the court would side, at the end of it, with a teenager who had never crossed an ocean in her life. Her name was Florence Blythe. She had grown up in England as the acknowledged illegitimate daughter of a man she had barely met. And in 1890, in a San Francisco courtroom that had spent 6 years sorting through 129 adult filings for the estate, a judge named James V. Coffey stood up and read her name into the record as the winner. Chapter 5. 129 claimants for $4 million. On the 4th of April, 1883, in San Francisco, a Welsh-born capitalist named Thomas Henry Blythe died suddenly at 60 with no will, no family in the United States, and about $4 million in property. He had been at his home in the city. He had complained of chest pain in the morning. By the middle of the afternoon, he was dead. The examining physician recorded the cause as heart failure. He was buried at Woodlawn Memorial Park Cemetery in the town of Colma, south of the city. Almost immediately, the newspapers began to run notices asking anyone with a claim on the estate to come forward. They came forward. Thomas Henry Blythe had been born Thomas Williams in the town of Mold in Flintshire, in the north of Wales, on the 22nd of July, 1822. His parents had been modest. He had emigrated as a young man to the United States, arriving in San Francisco in the years around the gold rush, and had never returned to Wales. He had made his fortune in California real estate. He had bought and subdivided the land that would become the Palo Verde Valley in eastern Southern California. He had, on the 17th of July, 1877, filed his first claim for Colorado River water at the point on the river that would become known as the Blythe Intake. He had appointed managers to build an irrigation system to bring that water to the desert. He had founded the settlement that would carry his name, Blythe, California, which sits today on the eastern edge of the Coachella Valley and holds his name in every road sign and every mailing address. He had done all of it as a bachelor. There was no wife on the census returns. There were no children in his household. There was no known family in the United States. And when he had died on the 4th of April, 1883, in the city of San Francisco, without warning and without a will, the entire $4 million estate had passed into the hands of a probate court that had no idea whom to give it to. The claimants began to file within days. Some of them had come across the story in the San Francisco papers. Some of them had read wire dispatches in the papers of New York and Chicago and Boston. Some of them had gotten the news by letter from friends in California. By the end of the first year, the court had recorded over 100 initial appearances. By the beginning of 1886, when the probate judge began to sort seriously through the claims, the San Francisco Chronicle reported 97 claimants on file. By the time the case reached trial in 1889, the total had reached 129 formal filings. Some of the claimants had been sifted out by the court's initial review. Others had withdrawn when the paperwork got harder. Almost 200 people, over the 7 years the case ran, had at some point made themselves publicly known as an heir of Thomas Henry Blythe. 3 of them claimed to be his wife. One had come from Wales, one from London, one from San Francisco itself. Each of the 3 women had a story. Each of the 3 stories was internally consistent. Each of the 3 papers had been notarized. None of the 3 had ever, in Blythe's lifetime, been publicly acknowledged by him as his wife. And each of the 3, in the probate court of San Francisco between 1886 and 1890, was asked to prove her paper. Beyond the wives, the court heard from cousins, from alleged half-brothers, from alleged half-sisters, from a man in Liverpool who claimed to have been Blythe's business partner in the 1850s and to have been owed a share of the estate under an unwritten agreement, from a Welsh farmer who produced a family Bible in which Blythe's name had, on the family's account, been written in by Blythe's own hand as a child in the sacred column beside the family's other names. The family Bibles multiplied through the case. Several family Bibles were placed on file in the court. Evidence rooms, all bearing the name Thomas Blythe or Thomas Williams, and all sworn to be authentic by the family that had brought them. The California statute at the heart of the fight was Section 1664 of the Civil Code. It let anyone who claimed to be the heir of a dead person bring a proceeding to be adjudged the heir. The statute did not require the claimant to have been publicly acknowledged during the deceased's lifetime. It did not require the claimant to have been named in a will. It did not require the claimant to prove a formal marriage between the deceased and the claimant's mother, so long as the claimant could prove that the deceased had received the child into his family and treated the child as his own. Section 230 codified the rule of adoption by recognition. Section 1387 codified the effect of institution as heir. Together, they were the doctrines that had made the free for all possible. The doctrines were also the doctrines that would, in the end, sift the free for all down to one person. Because in England, in the year Blythe died, there was a 10-year-old girl named Florence. She had grown up in modest circumstances. Her mother was an unmarried woman. Her father, whom she had barely met, was, on her mother's account, a Welsh-born California capitalist named Thomas Henry Blythe. Blythe had, in the years before his death, corresponded with the girl. He had sent money for her maintenance. He had, on more than one occasion, publicly identified her as his daughter in letters to friends and business associates in San Francisco. He had, in the specific California phrase, received her into his family. He had not brought her to San Francisco. He had not made her a public figure of his household, but he had, on the record of his letters, and on the testimony of the men he had corresponded with, acknowledged her. Around 1885, through a guardian in England, Florence Blythe filed a claim under Section 1664. She was represented by counsel who took her deposition in England and cross-examined the surviving witnesses to Blythe's California life. She did not, in the years the case ran, come to California in person. She was still a child. Her guardian and her lawyers argued the case in San Francisco. The three women who claimed to be Blythe's wife argued theirs. The cousins argued theirs. The alleged half-siblings argued theirs. The family Bibles were examined. The marriage lines were examined. The signatures were examined. The handwriting experts came forward. The probate judge, James V. Coffey, listened to it all. The trial began in 1889. It ran into the following year. Judge Coffey heard testimony from Welsh witnesses. He heard testimony from Liverpool witnesses. He heard testimony from San Francisco witnesses. He heard testimony from the men in Blythe's business who had received the letters in which Blythe had spoken of his daughter Florence. He examined the family Bibles. He examined the marriage lines. He examined the deposition Florence had given in England. He examined the records of Blythe's earlier life in Wales and in California. And in the end, he did what Section 1664 had been designed to let him do. He adjudged the heir. On the 1st of August 1890, in the San Francisco Probate Court, Judge Coffey held that Florence Blythe was the natural heir of Thomas H. Blythe under Section 1664, that Blythe had adopted her under Section 230, and that he had instituted her as his heir under Section 1387. The ruling was reported the next morning across California and across the country. She was, at that point, roughly 17 years old. She had beaten 128 rival claims. She did not come to San Francisco to hear the ruling read. She did not come to San Francisco for another year after that. She was, on the day her name was read into the court's decree, still in England. Chapter 6. A teenager in England beats 128 adults. On the 1st of August 1890, in the San Francisco Probate Court of Judge James V. Coffey, a 17-year-old girl who had never set foot in California was declared the heir to Thomas Henry Blythe. It sifted through every one of the 129 claims filed in the case, sorted them by category, dismissed most of them by name, and set out the reasoning for adjudging Florence the heir. The three women who had claimed to be Blythe's wife each received their own examination in the ruling. Each of the 3 marriage papers on Coffey's finding failed to withstand documentary and forensic scrutiny. All 3 claims failed on the paper. The cousins failed on the genealogy. The Welsh farmer's family Bible failed on the ink analysis. The Liverpool business partner failed on the absence of any documentary corroboration of the alleged partnership. The alleged half-siblings failed on the absence of any evidence that Blythe's mother had had other children by any other father. One by one, across 200 pages, Coffey took the 128 competing claims apart. Florence's claim did not fail on the paper, because Florence's claim was not, at bottom, about a paper. The evidence in her favour consisted of letters. Blythe's letters to his business associates in San Francisco, in which he had referred to Florence as his daughter and had discussed her upbringing. His letters to England, in which he had provided for her maintenance. The testimony of the men in San Francisco who had received these letters. The testimony of the men in England to whom Blythe had spoken of her in the visits he had made to the country in the last decade of his life. And, above all, the testimony of Florence's mother, who had given her deposition in England and had described in detail the years of Blythe's correspondence with her about their daughter's education and future. Coffey found that Blythe had publicly acknowledged Florence as his daughter within the meaning of Section 230. He found that Blythe had received her into his family within the meaning of the same section. He found that Blythe had, in effect, instituted her as his heir. He held that she was, under the statute, the natural heir of Thomas H. Blythe. The estate was hers. $4 million in real property, chiefly in the San Francisco business district and in the Palo Verde Valley. The city of Blythe, California, and the water rights on the lower Colorado River. The town lots her father had subdivided in the Coachella Valley. The San Francisco leases on which he had been drawing rent at the moment of his death. All of it. The losing claimants did not, as a rule, go quietly. Appeals filed. The California Supreme Court took the case. It affirmed. The federal courts took pieces of it in the litigation over specific parcels of Palo Verde land. 2 of those cases reached the United States Supreme Court. In 1899, in Blythe v. Hinckley, the court affirmed her title against a party named Boswell M. Blythe, who had continued to press a rival claim under the Palo Verde subdivision. In 1901, in a second Blythe v. Hinckley decision, the court affirmed her title again on a related question. By the time the litigation over specific parcels finally ran its course, more than a quarter of a century had passed since Thomas Henry Blythe had walked into his San Francisco home for the last time and complained of chest pain. Florence came to California in the years after the ruling. She lived in San Francisco. She married. Her married name was Hinckley. She did not, in the papers of the 1890s or the early 20th century, live any kind of a public life. There is no set-piece wedding at Grace Cathedral. There is no Newport house. There is no season in Paris. She held the estate. She held the water rights. She held the Palo Verde subdivision. She held the San Francisco leases. She lived, on the record of her adulthood, quietly. Her legacy, in the casebooks, is Blythe versus Hinckley. Her legacy on the map is the city of Blythe, California, which was named for her father before she was born and which she never lived in. Her legacy in probate law is the doctrine of adoption by recognition under Section 230, which stood on her ruling for decades and which was cited in California probate cases well into the 1960s. The framing of the case, in the papers of the 1890s, was the girl who had beaten 200 adults. The reality of the case was quieter than that. She was a proxy. She was represented throughout the case by counsel and by her guardian. She was, in the court's decree, the winner. She was, in the actual mechanics of the litigation, an absent figure whose name had been written on a pleading in San Francisco and who had grown up in Cambridgeshire while 128 strangers immolated themselves in a probate court 6,000 miles from her home. She was the exception in tonight's story. Her paper worked because she did not need to be the one to hold it up. Her guardian held it up for her. Her counsel argued for her. Her mother's deposition, taken in England, described a decade of correspondence with Thomas Henry Blythe about the daughter he had acknowledged, and a San Francisco probate judge, presented with the letters, ruled for her. She was young. She was absent. She was represented. She was a proxy. She won. The next woman in tonight's story was none of these things. The next woman was present in the courtroom. The next woman had been a professional woman in the city of San Francisco for a decade. The next woman produced not a stack of letters attesting to a father's acknowledgement of his daughter, but 4 pencil-written contracts of marriage against the estate of a Bonanza Silver King. And the next woman lost every one of them. She lost quietly. She was not the sensation of the daily papers. She did not make the front page for months at a time. She lost the way most women who tried this lost, on the handwriting, on the paper, on the pencil. Her name was Nettie R. Craven. She was a San Francisco school principal, and the man whose estate she claimed against was one of the 4 Irishmen who had struck the largest ore body in the history of the Comstock lode. Chapter 7. 4 pencil contracts against a Silver King. On the 28th of December, 1894, a former United States Senator from Nevada named James G. Fair died in San Francisco, leaving a will that gave $40 million to his 3 surviving children and nothing to any wife. He was 63 years old. He had been dying, in the last months of his life, of nothing dramatic. His doctors had described him as failing. His household staff had described him as tired. His daughters had visited him regularly at the hotel suite in which he had lived out his last decade. And on the 28th of December, in that hotel suite, he died. He was one of the richest men in America. James Graham Fair had been born on the 3rd of December, 1831, in the village of Clogher, in County Tyrone, in the north of Ireland. He had come to the United States with his father in 1843, at the age of 11. He had grown up on a farm in Illinois. He had moved to California in 1850, at 19, at the height of the gold rush. He had prospected the Feather River country not for placer gold in the streams, but for quartz gold in the rock. He had drifted east into Nevada. He had run a stamp mill on the Carson River. He had become superintendent of the Hale and Norcross mine at Virginia City in 1867. And in the years that followed, he had joined 3 other Irishmen, John William Mackay and James C. Flood and William S. O'Brien, in the partnership that would become known as the Bonanza firm. In 1873, in the Consolidated Virginia mine on the Comstock lode, the partnership found the ore body that came to be called the Big Bonanza. It was one of the largest silver strikes in the history of the United States. Over the 2 decades that followed, the Comstock produced more than $100 million in silver. Fair's share of the fortune made him one of the wealthiest men in the country. He reinvested. He bought San Francisco real estate. He built the narrow-gauge South Pacific Coast Railroad, which ran from Newark down the east side of San Francisco Bay through San Jose and Los Gatos, over the Santa Cruz Mountains to Felton. He sold the railroad in 1886 to the Southern Pacific for $6 million. He and Mackay owned the Nevada Bank of San Francisco, which for a time in the 1880s was the largest bank in America. In 1881, the Nevada legislature elected him to the United States Senate. He served 1 term. He was not much interested in Washington. He was called Slippery Jim. He was capable, cold, shrewd, and on the account of nearly everyone who worked with him, disliked. He had married Teresa Rooney in 1861, when she was running a boarding house in Virginia City. She had raised their 4 children, largely on her own. In 1883, she had divorced him on the ground of habitual adultery. The settlement she had extracted had been considerable. From that point on, Fair had lived as a divorced man in San Francisco. He had kept his hotel suite. He had kept his ledgers. He had kept his silence. He had also, in the last decade of his life, kept company with women. The papers had known this. The papers had reported it, obliquely, for years. The exact identities of the women he had kept company with were, in the manner of the San Francisco press of the 1880s, not always specified in print. What was specified in print, over and over, was that Fair was a man whose private habits did not match his public presentation. He was famously secretive. He was famously ungenerous. He was famously alone. He was, in short, exactly the kind of man against whose estate the pattern this video is tracing was most likely to run. When he died on the 28th of December 1894, and when his will was opened in San Francisco probate court in the first week of January 1895, the terms of the will named his 3 surviving children as the trustees and principal beneficiaries. Teresa Alice Fair, known throughout Newport and San Francisco as Tessie, then Mrs. Herman Ulrichs, received her share. Virginia Fair, later Virginia Fair Vanderbilt, received hers. Charles Lewis Fair, the surviving son whom his father had disinherited from the largest share during their late estrangement, received the reduced portion the will assigned him. The trustees were to manage the whole. The trust totaled $40 million. The will named no wife. Within weeks of the will's opening, a woman named Nettie R. Craven filed against the estate. She was a San Francisco school principal. She had been in the school system for over a decade. She was educated. She was respectable. She was known in the professional community of the city. And she claimed, in her filing, that she had been secretly married to James G. Fair, that they had been husband and wife under California law, and that as his widow, she was entitled to a widow's allowance from the estate. She asked for $5,000 a month. Her evidence was paper. She produced 4 contracts of marriage. Each was written in pencil. Each bore 2 signatures. Each was dated. The dates ran across the last several years of Fair's life. Her account, in the filings and in her later testimony, was that Fair had insisted on the pencil, that he had insisted on the secrecy, and that he had executed each of the 4 contracts in her presence in his hotel suite, as a private affirmation of a marriage he had refused to acknowledge in public. The Fair heirs contested every line. The trial that followed was the handwriting war. The Fair heirs hired the best forensic experts in San Francisco. Nettie Craven's counsel hired experts of her own. The pencil was examined under microscope. The paper was examined for age and manufacturer. The signatures were compared to the signatures on hundreds of Fair's other documents, on his checks, on his stock transfers, on his railroad papers, on his letters to his daughters, on his signed instructions to his hotel manager. The experts leaned over the papers under the courtroom lamps. They wrote reports. They took the stand. They testified. They were cross-examined. They wrote further reports. On the paper alone, the case was possible. Fair had, on the record of everyone who knew him, been a man capable of the secret private habits Nettie Craven's story described. The California statute permitted marriage by written declaration. The signatures, on some of the experts' testimony, resembled Fair's signature closely enough to be plausible. The pencil, on other testimony, could not be conclusively dated one way or the other. But there was no ceremony. There was no clergyman. There was no witness other than Craven herself. There was no third party who had ever, in Fair's lifetime, been told by Fair that Nettie Craven was his wife. There was no letter in Fair's hand to any of his intimates in which he had referred to her as such. There was no shared household. There was no shared bank account. There were no children. There was, in the end, only the woman and the 4 pencil contracts. The court ruled against her. The ruling came in the middle of the 1890s. The precise date and the specific court and the exact reasoning are preserved chiefly in the San Francisco court records of the Fair Estate contest and in the daily press of the trial, in the Examiner and the Chronicle and the Call. What survives at the level of the biographical record on Fair himself, in the sentences the modern historical accounts spare her, is a single line. Mrs. Nettie Cravens came forward claiming to be his wife. She presented her evidence to a court at trial, but lost the case. She was not the only woman who came forward against Fair's estate. Phoebe Cousins, the pioneering woman lawyer and suffragist, later claimed a relationship with Fair as well. Cousins's claim was not as extensive as Craven's and did not proceed to a full trial in the same posture. But her presence in the picture, alongside Craven's, was the pattern showing itself again. The dead Silver King had left women behind him. The dead Silver King had left an estate of $40 million. The dead Silver King had left a will that named no wife. And the women who had known him privately, in the last decade of his life, produced what they could produce in a courtroom. Paper. Nettie Craven's paper failed. Chapter 8. She lost and moved to Iowa and died in an asylum. When the court ruled against her, she left San Francisco, moved to Iowa, and spent her last days in a mental institution. The line in the biographical record on Fair is that direct. She moved to Iowa and lived in obscurity, spending her last days in a mental institution. That is all that survives, at the level of the sentence in the encyclopedia, of the end of a woman who had once been the principal of a San Francisco public school. The daily papers, for the weeks of the ruling, had covered the case. The San Francisco Examiner and the Chronicle had followed the handwriting testimony. They had run the courtroom accounts. They had summarized the forensic reports. They had described the pencil contracts. When the ruling came down, they reported it, and they described its reasoning, and they moved on. Within the year, the columns on Nettie Craven had thinned to occasional mentions. Within 2 years, she was no longer news. She left San Francisco. She went to Iowa. In Iowa, on the record that survives, she lived in modest circumstances. She did not, on the record, attempt any further legal action. She did not sell her story. She did not, so far as the record shows, sit for any interview with any Iowa or Illinois paper about the years she had spent in the Fair Estate contest. She lived. She grew older. And in her last years, at some point in the first years of the 20th century, she was committed to a mental institution. The exact institution, the exact date of her commitment, and the exact diagnosis have not survived in the standard biographical accounts of the case. What survives is the fact. She died in a mental institution. The pattern of the case was quiet in a way that made it, for the pattern this video is tracing, more revealing than the sensational cases around it. Nettie Craven had not been a courtroom sensation in the Sarah Althea Hill sense. She had not screamed in court. She had not carried a revolver in her handbag. She had not married her lawyer. She had not been the front page of the San Francisco Examiner for a month at a time. She had been a professional woman in her middle years who had produced 4 pencil-written papers and had asked a court to name her as the widow of a rich man, and the court had said no. When the court had said no, she had done what many women in the same position had done. She had left the city that would forever now remember her as the woman with the pencil contracts. She had gone somewhere the papers did not follow her. She had lived out the rest of her life in the kind of obscurity a defeated claimant most often ended in. She had died out of the record. The absence of the record itself is part of the story. Sarah Althea Hill's decline in the Sharon case was covered day by day. The papers were still running columns on Mrs. Terry's condition as late as 1936, 44 years after her commitment. Myra Clark Gaines's death in 1885 was a 2-column obituary in the New York Times. Florence Blythe's ruling in 1890 made every major American paper. Nettie Craven's Iowa death, so far as the surviving record shows, made a paragraph in the local paper and nothing more. While she was dying in Iowa, the Fair daughters were building the mansions. Tessie Fair Ulrichs at Newport built Rosecliff, one of the great Newport houses of the Gilded Age, on the design of Stanford White. It cost, in the years around 1902, about $2.5 million. Its ballroom, at 40 by 80 feet, was the largest in Newport. Tessie's balls in the house were, for the 2 decades of her prime, the ranking Newport events of their season. She married Hermann Ulrichs of the Norddeutsche Lloyd shipping lines in 1890, in the grandest wedding San Francisco had seen. Her father, still alive at the time, had not been invited. He had remained in his hotel suite. He had given her $1 million anyway as a wedding gift. Virginia Fair married William Kissam Vanderbilt II in 1902. Their houses on Long Island and in Manhattan and in Newport were as large as the Newport houses of the older Vanderbilts. Their money was fair money. The fair money was Comstock silver money and San Francisco real estate money and Nevada Bank of San Francisco money. It was, on paper, $40 million in a trust that the 2 daughters and their brother managed for the rest of their lives. The Fairmont San Francisco, at the crest of Nob Hill, is the monument the 2 daughters built to their father. Construction began in 1902. The daughters sold their interest in 1906, days before the San Francisco earthquake wrecked the hotel's neighborhood. The hotel opened in 1907 anyway, rebuilt after the earthquake on the same design. It stands today. The name on the marquee is Fairs. The daughters put it there. None of it, on the record, ever reached Nettie Craven. There is no Fair building she owned. There is no house at Newport she attended. There is no ball she danced at. There is no dowry she disbursed. There is no monument she built. The $40 million in the trust passed through the hands of the 2 daughters and their brother, into their marriages, into their houses, into their leases, into their bequests. She was in Iowa. She was, at the end, in a hospital ward the papers had not bothered to name. The Nettie Craven segment is the segment in which the whole mechanism of tonight's story becomes visible in its coldest form. She is the anthology's quiet loss. She is what happens when the paper does not work and the woman does not have a courtroom voice loud enough to keep the papers reporting her. She is what happens when a professional woman with a plausible private life produces 4 contracts in pencil against $40 million, and the court says no. She is what happens when the men the woman was suing are dead, and their heirs are hosting balls in Newport and building hotels on Nob Hill, and there is no one to fight with anymore, except a small paragraph in an Iowa death notice. She lost quietly. The last woman in tonight's story would lose loudly. Her husband would draw a Bowie knife in a federal courtroom in San Francisco. He would slap a United States Supreme Court justice at a railway station breakfast in Lathrop. He would die on the dining room floor from that justice's bodyguard's revolver at 7:10 in the morning on the 14th of August, 1889, with 80 to 100 people watching. She would spend 45 years locked inside the California asylum at Stockton for it. And on the 14th of February 1937, at 86, she would die there. Her name was Sarah Althea Hill. Chapter 9. The Rose of Sharon. In the fall of 1880, at 30, Sarah Althea Hill met a 60-year-old widower named William Sharon, who was the president of the Bank of California, the owner of the Palace Hotel, a sitting United States senator, and one of the richest men in America. She was, at the moment they met, in one of the more crowded parlors of a city that specialized in crowded parlors. She had been in San Francisco for 9 years. She had been at a great many parlors. She had, at every one of them, been beautiful. She had been born on the 26th of March, 1850, in Pleasant Hill, Missouri. Her father, Samuel H. Hill, had been a prominent attorney. Her mother, Julia Sloan, had been the daughter of a wealthy lumber dealer. Both her parents had died, while she and her older brother, Hiram Morgan Hill, were minors. They had been raised by relatives. When they had come of age, they had each received $20,000 from their parents' estate. In modern terms, $538,000 each. It was not a Vanderbilt inheritance. It was, however, the kind of money that let a young woman travel from Missouri to San Francisco and set up a life she could sustain for several years while she looked around to see what happened. She had been convent-educated. She had a reputation as a flirt. She had a temper. She was blue-eyed and rosy-cheeked, and, by her own account, and by every account that survives, beautiful in the manner the 1880s valued. She had, by her own testimony, learned to shoot a pistol. She could, she said, hit a 4-bit piece 9 times out of 10. She carried a small-caliber Colt revolver in her purse. She did not, she said, hesitate to threaten those who crossed her. In 1871, at 21, she had come to San Francisco with her brother and moved in with their relatives, William and Ada Bryan. She had circulated. She had speculated in the stock market with her inheritance and gradually dissipated most of it. She had, in the years around 1880, had an affair with an attorney named Reuben H. Lloyd. Lloyd had ended the affair. On the 10th of May, 1880, in Lloyd's office in San Francisco, she had drunk poison and attempted suicide. Her stomach had been pumped. She had lived. 5 months later, at a parlor gathering in the city, she had been introduced to William Sharon. Sharon was 60. He was a widower. His wife had died several years earlier. He had made his first fortune in Nevada silver, had gone to work as an agent of William Ralston Dotz's Bank of California, and had, on Ralston's suicide in 1875, become the bank's president. He was, at the moment, he met Sarah Althea Hill, one of the richest men in the United States. He owned the Bank of California. He owned the Palace Hotel of San Francisco, which had opened in 1875 as the largest hotel in the world, 800 rooms, a 7-story open grand court, hydraulic elevators lifting guests to their floors, a marble facade that ran a full city block. He owned the estate at Belmont, south of the city. He owned enormous holdings in Comstock silver stock. He had, in 1875, been elected by the Nevada legislature to the United States Senate. He was serving out his term. He was, by every account, not a man who wasted time. Within weeks of their meeting, according to Hill's account, and to the letters and receipts entered into the case's later evidence, Sharon had installed her in a room at the Grand Hotel, adjoining the Palace Hotel where he lived. He paid her, on his account and on hers, $500 a month. In modern terms, about $17,000 a month. He visited her regularly. He, on his account, considered the arrangement one of paid companionship. She, on her account, considered it a marriage. The paper, on her account, had been signed on the 20th of August, 1880. 2 months before their public introduction, on her testimony, they had already privately begun the relationship. On the 20th of August, in the Grand Hotel room, she said, Sharon had written out a signed declaration of marriage in his own hand and had signed it. She had signed it. He had sworn her to secrecy for 2 years. The reason, she testified, was that he was up for re-election to the United States Senate and could not afford the scandal that would result when his mistress back east heard about the marriage. He had, on her account, promised to acknowledge her publicly at the end of the 2 years. The 2 years did not end well. After just over a year, the relationship soured. She said he had begun a public relationship with another woman. He said she had begun to demand more than the arrangement had promised. On his account, he had tried to end the relationship. She had refused to leave the Grand Hotel room. So Sharon, in the manner of a man who owned the Bank of California, had ordered the hotel to evict her. The carpets in the room were ripped up while she was still in it. The door hinges were removed. The staff carried her belongings into the corridor. She had, in the end, accepted a settlement of $7,500, about $259,000 in modern terms, to leave. When he began a public relationship with the other woman, she filed for divorce on the ground of adultery. The suit was called Sharon versus Sharon. She filed as Sarah A. Sharon. She named William Sharon as the defendant. She produced the marriage declaration of the 20th of August, 1880, in her complaint. She asked the California Superior Court to grant her a divorce and to award her 1/2 of the community property Sharon had accumulated since the date of the marriage. The community property, on the 1872 California Civil Code, meant 1/2 of everything Sharon had made in 3 years of running the Bank of California, the Palace Hotel, the Belmont Estate, and his Comstock stock. It was, on paper, one of the largest divorce claims in American history. Sharon countersued in federal court to have the marriage declaration declared a forgery. The 2 cases ran in parallel from the summer of 1883 forward. The state court in San Francisco heard her divorce petition. The federal court in San Francisco heard Sharon's cancellation petition. 2 courts of concurrent jurisdiction, 2 decrees pending, 1 paper. Hill's counsel included, from an early stage, David S. Terry. Terry had been the 4th Chief Justice of the California Supreme Court. He had resigned that office in 1859 to fight a duel with United States Senator David C. Broderick, and he had killed Broderick with a single shot. He was famous throughout the West as one of the great trial lawyers of his generation and as a man who carried a Bowie knife. He was, in the year he became Hill's lawyer, in his late 50s. He would eventually marry her. Her patron and backer through the case was Mary Ellen Pleasant. Pleasant was a black woman in San Francisco that had spent the 1850s trying to prevent black testimony in its state courts. She had been in the forefront of the movement that had repealed the ban. She had, by the 1880s, become one of the wealthiest African-American women in the United States. She had made her money in a set of laundries and boarding houses in San Francisco, in stock speculation, and in short-term lending to San Francisco businessmen. She had bankrolled Sarah Althea Hill's suit against Sharon on the record, to the tune of about $5,000 for the defense. She had also, on Hill's account, served as the prime witness on the validity of the marriage contract. She had also, on the account of the papers of the case, brought a voodoo doll into the courtroom and threatened to use it to bring about William Sharon's death. The voodoo doll allegation was, on the record of the San Francisco Examiner and the Chronicle in 1884 and 1885, front and center in the coverage. Witnesses testified that Pleasant had cast spells over Sharon and poisoned his food. The papers ran the accusations. The papers ran the denials. In the historical view, a century later, in the phrase of the encyclopedia.com biography of Pleasant, rumors of Pleasant's practice of voodoo originated in racial hate and sexism. In the courtroom of 1884, the accusations went unrebutted in any way that would have stopped the papers from running them. And the papers, running them, gave Sharon's defense a tone that would color the whole case. The Rose of Sharon, on the account of her opponents, had been steered into her secret marriage by a black sorceress with a doll and a jar of powder. On the record of the case itself, she had been steered into her secret marriage by a wealthy widower who had installed her in a room adjoining his hotel and had signed a piece of paper with her. By the middle of 1884, at the height of the trial in Sullivan's Court, she was the sensation of San Francisco. The Examiner ran her on the front page for weeks. She was called the Rose of Sharon in every column. Sharon's defense filled the courtroom's public benches with the men and women of the city's social establishment. Pleasant sat behind her, day after day. Terry Cross examined the witnesses, and the paper of the 20th of August, 1880, sat on the table in front of the judge. The doors of the grand hotel room she had been evicted from had, by then, been rehung. But the paper she had produced in court was more dangerous than the door hinges. If the paper stood, William Sharon owed her, on paper, one of the largest divorce settlements in American history. If the paper fell, she was, on the court's finding, a mistress with a forgery. The state court ruled first. Chapter 10. Christmas Eve, 1884. On Christmas Eve, 1884, in the California Superior Court of Judge Jeremiah F. Sullivan, Sarah Althea Hill won her divorce from William Sharon, one half of his community property, alimony of $2,500 a month, and $55,000 in attorney's fees. The courtroom was full. The doors had been closed to the public a full hour before Sullivan came in. The papers had been announcing for a week that Sullivan would render his decision that day. He had heard the case over the course of several months. He had heard Sarah's testimony over multiple days. He had heard the testimony of Mary Ellen Pleasant, and of her housekeeper, and of Sarah's sister-in-law, and of the men and women who had been in and out of the grand hotel room over the years of the arrangement. He had heard William Sharon's testimony over multiple days. He had heard the testimony of Sharon's business associates, and of the Grand Hotel's manager, and of the men who had ripped up the carpet and the door hinges. He had heard, from both sides, on the paper of the 20th of August, 1880. Sarah had testified that Sharon had drafted it in her presence and signed it. Sharon had testified that he had never seen it before the case opened. The handwriting experts on Sarah's side had testified that the signature matched Sharon's. The handwriting experts on Sharon's side had testified that it did not. Sullivan had ruled for Sarah. The ruling was not a narrow one. It declared her the legal wife of William Sharon under the 1872 California Civil Code. It granted her a divorce on the ground of adultery. It awarded her one half of the community property Sharon had accumulated since the 20th of August, 1880. It awarded her alimony of $2,500 a month. It awarded her attorney's fees of $55,000. It named the paper of the 20th of August as valid. The Examiner, the following morning, ran the ruling as a triumph. The Chronicle ran it as a scandal. Pleasant, that evening, held a supper for Hill's team at her home on Octavia Street. Sharon appealed immediately. The appeal ran in the California Supreme Court through 1885. The appeal did not, on the technical questions of California marriage law of 1872, look strong for Sharon in the initial round. Sullivan's ruling had followed the statute closely. The written declaration doctrine of Section 55 was on Hill's side. The community property doctrine was on Hill's side. The adultery finding was on Hill's side. If the California Supreme Court affirmed the state ruling, Sharon would owe Hill something in the range of the largest divorce settlement in American history. Sharon's counsel had already been running a parallel track. In the fall of 1883, before Sarah's suit for divorce had gone to trial, William Sharon had filed in the United States Circuit Court for the District of California a suit called Sharon versus Hill. He had asked the federal court to declare the marriage contract of the 20th of August, 1880, a forgery, and to order it delivered up and cancelled. He had, in doing so, invoked the diversity jurisdiction of the federal courts. He was a citizen of Nevada, still holding his Senate seat. Hill was a citizen of California. The suit met the constitutional test for federal jurisdiction. It was assigned to Circuit Court Judge Lorenzo Sawyer and District Court Judge George M. Sabin, sitting together as circuit judges. Sawyer and Sabin heard the case in 1885. They heard the same witnesses. They heard the same handwriting experts. They heard the same testimony from Pleasant. They heard the same testimony from Hill. And they arrived at the opposite conclusion from Sullivan. On the 26th of December, 1885, in the federal court, Sawyer delivered the opinion. The marriage contract of the 20th of August, 1880, was a forgery. The court ordered it delivered up and cancelled. Sabin joined the opinion. The federal ruling was published on the 1st of January, 1886, in the San Francisco Examiner under the headline, "The Death Blow. The Sarah Althea Marriage Contract Declared a Forgery. 2 courts of concurrent jurisdiction. 2 opposing decrees." Sullivan in state court had said the paper was valid. Sawyer and Sabin in federal court had said the paper was a forgery. The California Supreme Court appeal was still pending on the state side. The federal ruling was live on the federal side. And in the middle of the year, 1886, there was no resolution as to which decree ultimately controlled. By then, the case was already changing shape. On the 13th of November, 1885, 6 weeks before Sawyer's ruling, William Sharon had died. He had been ill for months. He was in his mid-60s. His estate, on the paper filed with the San Francisco Probate Court, was worth in the tens of millions of dollars. The Palace Hotel, the Bank of California, the Belmont Estate, the Comstock stock. All of it passed on his death to his son Frederick Sharon and his son-in-law Francis G. Newlands. Hill did not stop. She produced a handwritten will, which she said she had found in Sharon's desk, that gave his entire estate to her and nothing to his son or son-in-law. Those who knew Sharon doubted its authenticity. The document was contested. Frederick Sharon and Francis Newlands took over the fight for the estate. And Hill, in the January of 1886, 6 weeks after Sawyer's federal ruling, married her lawyer. The wedding was held on the 7th of January 1886 at St. Mary's Church in Stockton, California, David Terry's hometown. Terry was 59. He was 33 years her senior. He had been Chief Justice of the California Supreme Court. He had killed a United States Senator in a duel in 1859. He had, throughout the Sharon case, been her lawyer. He had, in the year after Sharon's death, become her husband. The Sharon fight now had a new dimension. It was no longer a woman versus a rich man. It was a woman and her Chief Justice husband, both of them refusing to accept the federal court's finding that the marriage paper was a forgery, against the son and the son-in-law of the dead senator and the machinery of the federal court that had already ruled against the paper. The state court fight continued. In the 2.5 years after Sullivan's Christmas Eve ruling, the case ran up and down the California appellate courts, with wins and losses. The federal court fight also continued, with the Terrys refusing to surrender the marriage contract for cancellation as the federal court had ordered. In September 1888, both fights were still live. The federal court's insistence on cancellation of the paper was still unmet. Justice Stephen Johnson Field of the United States Supreme Court, sitting as Circuit Justice during his summer rotation on the Ninth Circuit, took the matter up. Field had already been the target of the Terrys' repeated threats in the years after Sawyer's ruling. Field would deliver, in the course of that September, the decree that provoked the courtroom incident, and Field would be, less than a year after that, sitting 5 feet away when the man who had drawn a Bowie knife in his courtroom died at a railway station breakfast in Lathrop, California. Chapter 11. The paper was declared a forgery. On the 1st of January 1886, the San Francisco Examiner ran the headline, "The Death Blow. The Sarah Althea marriage contract declared a forgery." The paper was, in its normal Sunday size, 4 pages of dense column type. The Sharon story ran on page 1, top of the fold, above the shipping news and the mining stock quotations and the Christmas correspondence. Inside the paper, on pages 2 and 3, were columns of Sawyer's opinion in the federal court, quoted at length. Sawyer's reasoning turned on the paper itself, on the ink, on the handwriting, on the manner of Sharon's signature, on the witnesses to the manner in which he customarily signed his private documents, on the handwriting experts, whose testimony Sawyer had reviewed at length, on the internal inconsistencies in Hill's own testimony over the manner in which the paper had been prepared, and on the credibility of Mary Ellen Pleasant, whose testimony Sawyer had assessed as unreliable. The state court, on Sullivan's Christmas Eve ruling, had assessed the same witnesses and the same evidence and had reached the opposite conclusion. Sullivan had believed Hill. Sullivan had believed Pleasant. Sullivan had believed the handwriting experts on Hill's side. Sawyer and Sabin had not. The tension between the two rulings was, in the American constitutional system of the 1880s, an unresolved problem. The doctrine that governed the relationship between state and federal courts of concurrent jurisdiction had been evolving since the case of Erie Railroad had not yet been decided. The Supreme Court had, in a series of cases across the 19th century, worked out the rules under which federal courts would defer to state court decisions on issues of state law. But those rules had not, in 1886, contemplated a case in which a state court and a federal court had reached opposite conclusions on the same paper in the same year, on the same question of fact. Sharon's counsel argued that the federal court's ruling controlled, because the federal court had exclusive jurisdiction over the cancellation of the paper as a matter of federal equitable relief. Hill's counsel argued that the state court's ruling controlled because the state court had ruled first, and because the question of marital status was, at its base, a question of state law. Neither argument fully won. Neither argument fully lost. The case ran, from January 1886 forward, on parallel tracks, with each court refusing to yield. Meanwhile, William Sharon had been buried at Laurel Hill Cemetery in San Francisco on the 16th of November, 1885. His son Frederick and his son-in-law Francis G. Newlands had taken up the case in his place. Newlands was, by then, a rising figure in Nevada politics, who would later become a United States Senator from that state, and who would later still be one of the principal authors of the Reclamation Act of 1902. He was, at the moment he took over the Sharon fight, the executor of his father-in-law's estate. He and Frederick Sharon would fund the continued litigation for the next 4 years. Hill's marriage to David Terry, 7 weeks after Sawyer's federal ruling, was covered by the papers of both San Francisco and Stockton at length. St. Mary's Church in Stockton was, in the 1880s, a small parish church at the center of a small California town. The wedding was quiet. The papers were not invited. but the papers found out anyway, and the columns on the wedding ran the following morning. Terry was famous throughout the West. His duel with Broderick in 1859 had been the most sensational duel in California history. He had, on the account he gave, defended a public insult from Broderick that could not have been resolved any other way. He had resigned his Chief Justiceship of the California Supreme Court to fight the duel. The two men had met at the appointed field near Lake Merced, south of San Francisco. Broderick's pistol had discharged prematurely into the ground. Terry's had not. Broderick had died 3 days later of his wound. Terry had been tried and acquitted, and had returned to the practice of law. He had never held elected office again. He had, in the years that followed, developed a reputation as a lawyer for cases that other lawyers would not take. He was known for his temper. He was known for his Bowie knife. He had, on one occasion in the 1850s, stabbed a member of the San Francisco Vigilance Committee in the neck with his knife, and had been exonerated only when the man survived. He was, throughout the West, one of the most feared trial lawyers of the era. He had also, in the years of the Sharon case, been Hill's counsel. He had also, on Sarah's account and on his own, fallen in love with her. The wedding at St. Mary's on the 7th of January 1886 was Terry's second marriage. His first wife had died. Sarah's marriage to Terry was, if the federal court's ruling stood, her first marriage. If the state court's ruling stood, it was her second, and the second was arguably bigamous because she was still married to William Sharon's estate on the state court's finding. The paperwork of the courts, in the wake of the wedding, changed captions. Sarah A. Sharon became Sarah A. Terry. The Sharon case, in its remaining rounds, ran as Terry versus Sharon and Sharon versus Terry. The knife Terry carried in his coat became, by degrees, more prominent in the daily coverage of the case. He was seen with it at the courthouse. He wore it into hearings. He drew it, at one point in 1887, in the corridor of the federal building to make a point to opposing counsel. By the summer of 1888, the federal court was insisting that the paper be delivered up for cancellation, and the Terrys were refusing to deliver it. The case had, in Justice Field's understanding as circuit justice, become a challenge to the authority of the federal court. Field was, at that point, one of the most prominent associate justices of the United States Supreme Court. He had served on the court since 1863. He would serve until 1897. He had been, throughout his career, a defender of federal judicial authority against state resistance. In September 1888, sitting as Circuit Justice on the Ninth Circuit, Field would take up the Sharon matter and would issue the final decree. He would rule, definitively, that the paper of the 20th of August 1880 was a forgery. And Sarah Althea Hill Terry, sitting in the courtroom as the decree was read, would stand up and reach for the revolver in her handbag. Chapter 12. The Bowie Knife and the Dining Room at Lathrop. On the 3rd of September 1888, in a federal courtroom in San Francisco, Justice Stephen J. Field of the United States Supreme Court delivered the decree that Sarah Althea Hill's marriage contract was a forgery, and she stood up and reached for the revolver in her handbag. Field had been sitting as Circuit Justice for the Ninth Circuit during his summer rotation. He had heard the arguments in the Sharon matter over the previous months, along with Judge Lorenzo Sawyer and District Judge George M. Sabin. He had taken the matter under advisement. On the 3rd of September, from the bench, he read the decree. The decree confirmed the December 1885 ruling of Sawyer and Sabin. The paper of the 20th of August 1880 was a forgery. The court ordered it, once more, delivered up and cancelled. The Terrys were ordered to comply with the previous decree that they had, for 2.5 years, refused to comply with. Sarah Althea Hill. Terry, on hearing the decree, stood up in her seat in the courtroom's public gallery. She screamed obscenities at Justice Field. She fumbled in her handbag for the small caliber Colt revolver she was known to carry. Marshal John Franks moved toward her to escort her from the courtroom. Marshal Franks put his hand on her arm, and her husband, sitting beside her, rose from his seat and drew his Bowie knife. Terry, in the courtroom, was 6'3" and 250 pounds. He was 65. He was armed with an unsheathed Bowie knife. Marshal Franks stepped between him and Justice Field. Terry swung. The knife did not connect. Terry's other fist did. He hit Marshal Franks in the mouth. Franks lost a tooth. Other marshals in the courtroom drew their sidearms and moved forward. Deputy Marshal David Neagle, among them, drew his pistol and put it in Terry's face. Spectators subdued Terry. They led him out of the courtroom. In the corridor, he pulled the Bowie knife again and threatened all around him. He was subdued a second time and arrested. Sarah, still fighting in the gallery, was subdued and arrested. Justice Field ordered both Terrys returned to the courtroom. He sentenced David Terry to 6 months in jail for contempt of court. He sentenced Sarah Terry to 1 month. Both Terrys served their sentences in the county jail at Alameda. Sarah, during her sentence, was pregnant. She suffered a miscarriage in jail. In May 1889, near the end of David Terry's sentence, the United States Supreme Court refused to review the order that had invalidated Sarah Terry's marriage contract. In July 1889, the California Supreme Court reversed its own earlier position and ruled that because the alleged marriage had been kept secret, it was never legally a marriage under the 1872 California Civil Code. It was the final defeat of the state track. Sullivan's Christmas Eve ruling was 4.5 years later undone. David Terry was released from the county jail in Alameda. Sarah had already been released from her shorter sentence. They returned to Fresno, where Terry maintained a law practice. From Fresno, throughout the summer of 1889, they made regular threats against Justice Field. The threats were reported in the papers. They were passed to the United States Attorney General, William H. Miller, in Washington. In May 1889, Miller had issued a directive to United States Marshal John Franks in San Francisco, appointing David Neagle as deputy marshal with specific responsibility to protect Justice Field. Miller's directive read, in part, that it was due to the dignity and independence of the court and the character of its judge that no effort on the part of the government should be spared to make them feel entirely safe and free from anxiety in the discharge of their high duties. Neagle was 5'7" and 145 pounds. He carried a .45 caliber Colt revolver. On the 14th of August, 1889, at 7:10 in the morning, a train pulled into the railway station at Lathrop, California, a small stop in the San Joaquin Valley between Stockton and Fresno. The passengers disembarked for breakfast at the station restaurant. Among the passengers were David Terry and Sarah Terry, returning to Fresno from a court appearance. Also among the passengers, unknown to the Terrys, were Justice Field and Deputy Marshal Neagle, returning from Los Angeles. Sarah, entering the dining room, saw Field seated at a breakfast table with Neagle. She immediately turned around and left the dining room. She went back to her railroad car. Her satchel, on the record, was in the railroad car. Her satchel contained her Colt revolver. On the record, it also contained Terry's Bowie knife. While she was gone, David Terry saw Field. He crossed the dining room. He walked up behind Justice Field, whose back was to the door. The San Francisco Chronicle the next morning reported that Terry slapped Field on the cheek twice with such force that his glasses were knocked off. Other reports described Terry as attempting to slap Field or to grab him by the whiskers. Neagle rose from his chair. He said, "Stop that. I am an officer." Terry drew back his hand again. Neagle drew his .45 caliber revolver. He fired once. The bullet entered Terry's heart at point-blank range. Terry fell backward. Neagle fired again as Terry fell. The second bullet nicked Terry's ear. Terry was dead when he hit the floor. Neagle turned to the 80 to 100 people in the dining room. He said, "I am a United States Marshal, and I defy anyone to touch me." Justice Field, still seated, told the room that Terry had assaulted him and that his officer had shot him. Sarah returned from the railroad car. She saw her husband on the dining room floor. She threw herself over his body. She screamed at the crowd to search him. She insisted that he was unarmed. She demanded that his coat be opened. The proprietor of the dining room, who had already searched her satchel and had found her pistol within it, held her at the door. Terry's Bowie knife was later found in her satchel with her pistol. Neagle, in his testimony after the shooting, said he thought he had seen her covertly remove the knife from Terry's vest as she threw herself over his body. Neagle and Field returned to the train and locked themselves in their cabin. Sarah tried to enter the car, saying she wished to slap Field. Neagle told the conductor to keep her out, or he would kill her too. The Lathrop constable arrived. The Stanislaus County Sheriff arrived. Neagle produced the letter of appointment from Attorney General Miller. The constable arrested him anyway and took him to the county jail in Stockton. Neagle refused to say anything about the shooting until federal counsel arrived. The United States Attorney in San Francisco filed a writ of habeas corpus for Neagle's release. The Federal Circuit Court granted the writ. Neagle was released from state custody. San Joaquin County Sheriff Thomas Cunningham, with the aid of the state of California, appealed to the United States Supreme Court. The appeal turned on whether Neagle had acted in pursuance of a law of the United States when he shot Terry. In the case that came to be known as In re Neagle, 135 United States 1, decided in 1890, the Supreme Court held that federal officers are immune from state prosecution for actions taken within the scope of their federal authority. The doctrine was a landmark of federal supremacy. It has been cited in American courts continuously to this day. It was born from a slap in a railway station dining room, a bullet through the heart of a former Chief Justice of California, and a scream from a woman kneeling over her husband's body, insisting he was unarmed, while his knife lay hidden in her satchel with her pistol. The paper of the 20th of August, 1880, was, by the end of the year, 1889, a settled forgery in every federal court in the United States. The state track had collapsed in July. The Sharon estate had been finally settled in favor of Frederick Sharon and Francis Newlands. The Palace Hotel, the Bank of California, Belmont, the Comstock stock. All of it had passed as Sharon's will had directed, with no share to the Rose of Sharon. David Terry was buried in the Terry family plot in Stockton Rural Cemetery, in the town where he had married her 3.5 years earlier at St. Mary's. She had lost the paper. She had lost the estate. She had lost the state court. She had lost the federal court. She had lost her lawyer to a bullet fired by a federal marshal 5 feet away from a Supreme Court justice at a dining room breakfast. She had also, on the account of the papers of San Francisco in the weeks that followed, lost her mind. Chapter 13. 45 years in the California Asylum at Stockton. On the 11th of March, 1892, after a brief examination by the Insanity Commission, Sarah Althea Hill Terry, aged 41, was committed to the California Asylum at Stockton and remained there until she died on the 14th of February, 1937, aged 86. She was inside the institution for 45 years. She entered it as a widow who had spent the previous 2.5 years unraveling in public in the streets of San Francisco. She left it in a wooden coffin carried out by cemetery attendants. The unravelling had been visible for months. In the fall of 1889, in the weeks after Terry's death at Lathrop, she had begun to hire mediums. She had believed that if she found the right medium, she could reach David through a séance. The 19th century American spiritualist movement, which had grown out of the Fox sisters' cottage in upstate New York in 1848, had by the 1880s become a nationwide industry. Every large American city had its rooms in which mediums held séances for a fee. San Francisco had more than most. Sarah went to all of them. She sat at their tables. She held their hands. She listened for David. She heard, or believed she heard, many voices. She heard David tell her he loved her still. She heard David tell her to fight on. She heard David tell her, on one occasion, that Justice Field had personally arranged for his murder. She paid the mediums. She hired more mediums. When one medium disappointed her, she moved on to the next. She also began, in the winter of 1889, to believe that she was being tormented by electricity and by hypnotism. She could not, she said, sleep. She would not eat unless one of her few remaining friends prepared the food. She wandered San Francisco in the mornings, in clothes she had slept in. She stopped taking baths. She stopped combing her hair. The Rose of Sharon of 1884, whose beauty had been the substance of a dozen front-page columns in the Examiner and the Chronicle, was replaced by a middle-aged woman in an unwashed dress with a stopped watch pinned to her collar and a satchel slung over her shoulder. The satchel still contained her Colt revolver. She would, from time to time, produce the revolver. She threatened judges. She threatened lawyers. She threatened newspaper reporters. On the 14th of February 1892, the San Francisco Call ran a column under the headline, "Hopelessly Unbalanced." It described Mrs. Terry's condition. It described her spiritual consultations. It described her sleeplessness. It described her wandering. It described her belief that she was being tormented by electricity. The Call, in the phrase of the column, wrote that she constantly talked to spirits, especially that of her husband, and could not sleep. She had periods of violence and believed that she was being tormented by electricity and hypnotism. She had been abandoned, by that point, by her relatives. Her brother, Hiram Morgan Hill, for whom the California town of Morgan Hill had been named, had long since gone his own way. Her Missouri family, whom she had not seen in years, did not intervene. She had, at the moment the Call ran its column, 2 friends left. Neither was a Missouri relative. Neither was a Sharon or a Terry or a Newlands. The first was R. Porter Ashe, a San Francisco lawyer who had known her socially for over a decade. The second was Mary Ellen Pleasant. Pleasant, in the weeks after the Call column, initiated the paperwork to have Sarah committed. She saw, on any honest view of the situation, no other option. Sarah could not care for herself. She had no money. She had no relatives who would take her in. She had no husband. She was, on the medical view of the day, insane. The California asylum at Stockton would take her. And there, at the very least, she would be fed and housed and prevented from doing further harm to herself. The Insanity Commission examined her briefly on the 10th of March, 1892. Sarah, in the examination, ranted, talked to spirits, and described her tormenting electricity. The commission found her, without difficulty, insane within the meaning of the statute. On the 11th of March, 1892, she was committed to the California Asylum at Stockton, later known as the Stockton State Hospital. She was 41. She had been born on the 26th of March, 1850. She had, in 1 week, been 42. The diagnosis was dementia praecox, an early term for what would later be called schizophrenia. She was extremely violent on admission. She had to be restrained. She was, for the first several years of her commitment, kept in isolated rooms and given sedatives. She attacked staff. She attacked other patients. She would not eat. She would not bathe. She spoke night and day to David. The years passed. By the middle of the 1890s, she had begun to settle into the institution. The violent outbursts became less frequent. The delusions began to shift shape. By the turn of the 20th century, in the phrase of a hospital report much quoted in the popular accounts of her case, she had adapted to her life in the institution. She had begun, in her mind, to inhabit a different world. She was, she believed, a rich and grand lady of high birth. The hospital ward she lived in was, she believed, her mansion. The nurses who attended her were, she believed, her servants. The other patients were, she believed, her guests. The meals brought to her on trays were, she believed, the courses of a great dinner in her own dining room. She would summon the servants by ringing a small bell she had been permitted to keep beside her bed. She would give the servants elaborate orders about the placement of the table linen at dinner. She would announce to the other patients, as they were led into the ward's common room, that they were welcome to her hospitality and that the string quartet would begin playing shortly. There was no string quartet. There was no table linen. There was no dinner other than what the hospital brought her on a tray. She lived, for the last 3 decades of her life, in a delusion in which she was, at last, the wife of William Sharon, or the wife of David Terry, or some composite of the two, at the height of a life she had never actually had. Dr. Asa Clark, superintendent of the Stockton State Hospital in her later years, called her the hospital's best-known patient. He was not the first to say so. Every superintendent between 1892 and 1937 had at some point made the same observation. She was, in the hospital's own file, its most famous patient. She was, on the record, its longest resident. She was, in the phrase of a Fresno Morning Republican article of July 1894, one of the great minds that failed. Visitors came, occasionally. Authors researching the case came. Journalists writing feature articles for the Sunday supplements came. Old San Francisco figures, seeking the story of the 1880s from a woman who had lived at the very center of it, came. She received none of them well. She was rude to journalists. She was indifferent to authors. She was suspicious of anyone who claimed to have known her from before. She had, in her own mind, entered a new life in a great mansion, and the past, on her rare acknowledgement of it, was a story she did not want to remember. The Sharon estate, in the years of her commitment, ran its course. Frederick Sharon lived out his life in California. Francis Newlands became a United States Senator from Nevada. The Palace Hotel was rebuilt after the 1906 earthquake in a form that stands today. Belmont passed through several owners and eventually became an educational campus. The Bank of California, weakened by the panic of the 1870s and never fully recovered after Ralston's death, was eventually absorbed into other San Francisco banks. Mary Ellen Pleasant, who had committed Sarah to the asylum, died in 1904 at 90, in poverty, having outlived nearly all of her San Francisco investments and having been erased in the racially hostile press of the 1890s as a voodoo queen. The last of Sarah's few connections to the world outside the hospital was gone. Sarah lived on. The 1910s passed. She grew old. Her hair went white. Her handwriting, on the occasional letters she wrote from the hospital, became childlike. The 1920s passed. The bell she rang to summon her imaginary servants was still on her bedside table. The fair daughters at Newport, Tessie Ulrichs, still ranked as the queen of the Newport ball season, died in 1926. The Fairmont Hotel on Nob Hill, opened in 1907, was one of the great hotels in the country. The Vanderbilts held their Long Island houses. Virginia Fair Vanderbilt outlived her husband. New York, San Francisco, and the world of Newport that Sarah had never entered rolled on in the columns of the papers she was no longer permitted to read. She turned 70 in 1920. She turned 80 in 1930. She turned 86 on the 26th of March, 1936. She died on the 14th of February, 1937, at the Stockton State Hospital, of pneumonia. She had been in the institution for 44 years, 11 months, and 3 days. The cause of death was recorded by the hospital physician as pneumonia. She was 86. She had entered the asylum at 41. She had never left. Cornelia Terry, the granddaughter of her husband David S. Terry, stepped forward at the news of Sarah's death to arrange a proper burial. She had known Sarah only as a distant relative. She had, on the record, never met her. But she paid for the burial. She saved Sarah from being interred in the pauper's plot on the hospital grounds. She arranged for Sarah to be buried in the Terry family plot in Stockton Rural Cemetery, beside David, in the town where he had grown up and where she had married him 51 years earlier at St. Mary's Church. The Oakland Tribune, on the 16th of February 1937, ran a column on Sarah's death under the headline, "Pauper's Grave Escaped by Sarah Althea Terry." It was, in a life measured in the columns of the San Francisco papers, one of the last columns on her name. The paper of the 20th of August, 1880, on the record of the federal court, had been ordered surrendered to the court for cancellation in 1886. Whether the physical document had ever in fact been produced for cancellation, or whether it had been destroyed by the Terrys, or whether it had passed into the hands of some sympathetic archivist, or whether it had been lost, is not entirely clear from the surviving record. What is clear is that the paper is no longer in circulation. It exists on the record only as a court file, referenced by a legal citation in the archives of the Ninth Circuit. What outlived her was not the paper. What outlived her was in re Neagle, the constitutional doctrine that had been born on the dining room floor at Lathrop when a deputy marshal shot her husband dead over a slap. That doctrine, cited today in American courts as an authority on the immunity of federal officers from state prosecution for acts done within the scope of federal authority, is her most durable legacy. She had not intended it. She had, in the moment of Neagle's shot at Lathrop, wanted only to save her husband. She had spent the following 45 years in an asylum ward in Stockton, believing in her delusion that she was the mistress of a great mansion. And a doctrine she had never read and would never have read stands today in the citations of federal court opinions as the enduring paper produced by her case. Chapter 14. The Monuments and the Missing Names. Walk through the buildings that survived them, and you will find that the men are on the walls and the women are not. The Palace Hotel of San Francisco, at the corner of Market Street and New Montgomery, still stands. It burned in the 1906 earthquake and was rebuilt in a smaller form on the same footprint. The plaque outside the current building names William Sharon and William Ralston as its founders. It does not name Sarah Althea Hill. It does not name the Grand Hotel room adjoining it in which the arrangement of the 1880 summer was conducted. The Grand Hotel is no longer standing at the site. Belmont, the estate south of San Francisco that William Sharon inherited from William Ralston and used through the 1880s, still stands in restored form. The plaques acknowledge Ralston and Sharon. They do not acknowledge Sarah Althea Hill. The Bank of California building on California Street in San Francisco rebuilt after the earthquake, is still in commercial use. The plaque at the entrance names William Ralston and William Sharon, and the succession of the bank's presidents through the late 19th century. The plaque does not mention Sharon versus Sharon, or the divorce petition of 1883, or the federal ruling of 1885 that the marriage contract was a forgery, or the shot fired at Lathrop on the 14th of August, 1889. The Fairmont Hotel, at the top of Nob Hill in San Francisco, was completed in 1907 and stands as the monument the Fair daughters built for their father, James G. Fair, the Comstock Silver King. The name on the marquee is Fair's. The name on the hotel's history is Tessie Fair Ulrichs's and Virginia Fair Vanderbilt's. There is no mention in the hotel's published history of Nettie R. Craven, the San Francisco school principal who produced 4 pencil-written contracts of marriage against the estate that funded the hotel's construction. There is no mention of Phoebe Cousins, the pioneering woman lawyer who had also claimed a private relationship with James G. Fair. Craven is not in the hotel. Craven is not in the plaque. Craven is not in the guidebook. She is in Iowa, in a mental institution, in a grave that does not survive in the standard cemetery records of the state. She is not on the wall. Rosecliff at Newport, built by Tessie Fair Ulrichs on Stanford White's design, cost about $2.5 million and opened in 1902 with a ballroom the largest in Newport. It is today a preserved house of the Newport Preservation Society. Its history, presented to the visitors who pay for tickets to walk through the ballroom and the grand entrance hall, credits Tessie and mentions James G. Fair as the source of the fortune that built it. It does not mention Nettie Craven. It does not mention Teresa Rooney, who divorced Fair for habitual adultery in 1883. It does not mention the 1818-94 contest against Fair's estate. It presents Rosecliff as a monument to a great American hostess, which, in truth, it was. But the great American hostess had a sister who did not appear at Rosecliff, and a father who did not appear at her sister's San Francisco wedding, and a mother who had raised the children on her own after divorcing the father for habitual adultery, and a stepmother in every conceivable sense of the term who lived in the year Rosecliff opened, in an Iowa mental institution. The city of Blythe, California, on the Colorado River, is Thomas Henry Blythe's monument. The city was named for him before Florence was born. The plaque at the city's welcome sign credits him with the Palo Verde Valley irrigation system and the July 1877 water rights filing at the Blythe intake. There is no plaque in the city naming Florence Blythe Hinckley, the daughter who inherited the estate and who held the water rights and the Palo Verde subdivision for the rest of her life. The Palo Verde Irrigation District, still in operation today, distributes Colorado River water to the fields of the Palo Verde Valley on the primary water rights Blythe filed in 1877. The district's published history credits Thomas Henry Blythe as its founder. It does not mention Florence. Canal Street in New Orleans, on which much of Daniel Clark's estate had once stood, is one of the great streets of the American South. Its history is on the walls of half a dozen historical societies and libraries in the city. Daniel Clark, as the earliest owner of much of the street's real estate, is named in every published account. Myra Clark Gaines is mentioned in some of the more comprehensive accounts as the plaintiff in a 57-year lawsuit. She is not the name on the plaques. The pattern of the monuments is the pattern of the whole story. The buildings and the streets and the subdivisions and the mining claims survive. The men who owned them survive on the plaques. The women who fought for them, who married them and were repudiated by them, who bore them children they never acknowledged, who signed private papers with them and produced the papers in court after they died, are not on the walls. The pattern is not accidental. The pattern is what the paper was for. The paper was the mechanism by which a woman who had been erased from the public record of a rich man's life could reintroduce herself into the record of his estate. The paper worked, in Florence Blythe's case, when the woman was a proxy, and the court accepted the letters as proof of receipt into the family. The paper did not work in Nettie Craven's case, or in Sarah Althea Hill's case, or, on the final tally of the money reaching her heirs, in Myra Clark Gaines's case. But the paper, in every one of the 4 cases, produced a court record. The court record entered the archives. The archives are, today, publicly searchable. The San Francisco court records of the Fair Estate contest exist. The federal court records of Sharon versus Hill and In re Neagle exist. The New Orleans court records of the Gaines suits exist, reorganized several times in the century since her death, and now held in the historic New Orleans collection and at the Howard Tilton Memorial Library at Tulane. The London and Cambridge and San Francisco records of Blythe versus Hinckley exist. The record of the 4 women is not on the plaques of the buildings. The record of the 4 women is in the papers they filed. The buildings are the monuments of the men. The papers are the monuments of the women. There is a lesson buried in the difference. The buildings, in the standard American reading of the Gilded Age, are the story. The Palace Hotel, Belmont, the Bank of California, the Fairmont on Nob Hill, Rosecliff at Newport, the city of Blythe on the Colorado River, Canal Street in New Orleans. These are the surfaces on which the modern imagination of the era rests. The papers are a footnote. But the papers are what the women left. The papers are what a woman, in the era of coverture and the aftermath, could actually produce. She could not build a palace hotel. She could not run a bank. She could not open a mine on the Comstock. She could sign a piece of paper with a rich man. She could produce the paper after he was dead, or after he had tried to walk away. She could take the paper to court, and she could, at least, force the court to name her. The court, on the record, named Florence Blythe. The court, on the record, named Myra Clark Gaines. The court did not name Nettie Craven, and it did not, in the end, name Sarah Althea Hill. But the court records survive. The papers survive. The women survive in them. The buildings are what a rich man could build. The papers are what a woman could file. That, on the final accounting, is what the monuments and the missing names have to say about the difference between the two. Chapter 15. Where the papers went. The papers themselves outlived the women who wrote them. The 1813 will of Daniel Clark, the missing will that Myra Clark Gaines chased for 51 years, was never found. It was reconstructed from witness testimony. The nurse, Harriet Harper Smythe, who had been in the room when Clark signed it a month before his death, described the paper in court. Colonel Joseph Belchasse, Clark's friend, described what Clark had told him about the paper. Other witnesses described the executors it named, and the beneficiaries it identified, and the language it used. In 1858, the Louisiana Supreme Court admitted the will to probate as if the physical paper were in the court's hand. The reconstructed text of the 1813 will is preserved in the case records of the Louisiana Supreme Court and in the archives at Tulane. The physical document, in whatever form it originally existed on the 10th of July 1813 when Clark supposedly signed it, is not there. Wherever it went, whether Relf and Chew burned it, or whether it was carried away in a stack of Clark's other papers after his death, or whether it was misplaced in the executor system that swallowed the rest of his estate, the physical will is gone. The record of it is a court's finding of fact, 70 years after the fact, based on the testimony of witnesses who died decades before the ruling. The rival marriage lines from the Blythe case are on the record of the trial, preserved in the case files. The 3 papers each of the 3 women who claimed to be Blythe's wife produced are entered as exhibits in Judge Coffey's ruling of the 1st of August 1890. All 3, on the ruling, were forgeries or misdated documents. All 3 are preserved in the court's evidence rooms. The family Bibles from the Blythe case are also preserved in the court archive. The 4 pencil-written contracts of marriage from the Fair case, produced by Nettie R. Craven against the estate of James G. Fair in the middle 1890s, are preserved in the San Francisco Probate Court archive as well. They are, on the modern history's account, still in pencil, on paper of the type used in San Francisco office supply stores of the 1890s, bearing signatures identified as Fair's by the handwriting experts on Craven's side, and rejected as Fair's by the handwriting experts on the estate's side. The pencil is faded, but legible. The signatures are visible. The contracts are, in every sense, real objects on the shelves of a court archive. They exist. Whether Fair signed them is, on the court's finding, not the case. Whether Fair signed them is, on the human record, unknowable at this distance. What is knowable is that Nettie Craven produced them, that a court examined them, that a court ruled against them, that she left San Francisco, that she moved to Iowa, that she died in a mental institution, and that the 4 contracts are on a shelf in San Francisco today. The marriage declaration of the 20th of August 1880, the paper on which Sarah Althea Hill built her case against William Sharon, was ordered by the federal court to be delivered up and cancelled on the 26th of December 1885, and again in Justice Field's decree of the 3rd of September 1888. Whether the physical paper was actually surrendered is not entirely clear. The Terrys, before David Terry's death, refused to comply with the surrender orders. Whether Sarah, after Terry's death, ever surrendered the paper is not recorded. Whether the paper was destroyed by Sarah, or seized by the marshals, or hidden by Mary Ellen Pleasant, or lost in the turmoil of the years between the Terry shooting and Sarah's asylum commitment, is not recorded either. What is recorded is that the paper is not in the federal court's archive. There is no surviving physical copy of the 20th of August 1880 declaration. There are copies of the text, transcribed by the courts that heard the case. There are contemporaneous photographs of the paper that appeared in the newspapers during the trial. There is no original. The absence of the original is the appropriate ending for the case. The paper that Sarah Althea Hill produced in court in 1883, that Sullivan's California Superior Court declared valid on Christmas Eve 1884, that Sawyer's federal court declared a forgery in December 1885, that Justice Field's decree of September 1888 confirmed a forgery, that provoked a Bowie knife in a federal courtroom and a slap in a railway station dining room and a bullet through a former Chief Justice's heart, and that in the end committed a woman to 45 years in the California asylum at Stockton. The paper itself is nowhere. It is a record. It is a citation. It is a court finding. The paper's physical existence, if it ever existed, is gone. What is not gone is in re Neagle. The doctrine born on the dining room floor at Lathrop, when Deputy Marshal David Neagle fired a .45 caliber bullet through the heart of former Chief Justice David S. Terry over a slap at Justice Stephen Field, is cited in American courts today. It stands for the proposition that a federal officer, acting within the scope of federal authority, is immune from state prosecution for the acts done within that scope. It has been cited in cases about federal marshals, about federal agents, about federal prosecutors, about federal wildlife officers, and about federal border enforcement officers. It has been cited in cases about presidential immunity from state prosecution. It has been argued in the Supreme Court in multiple contexts in the century after its decision. It is, in the standard federal court's casebooks, the constitutional doctrine that answers the question of federal supremacy in the sphere of federal executive action. The paper Sarah Althea Hill wanted to produce in court was the marriage declaration of the 20th of August, 1880. The paper her case actually produced, in the archive of the federal courts of the United States, is the opinion of the Supreme Court in Re Nagel, 135 United States 1, decided the following year. She did not intend it. She did not read it. She was, at the moment it was decided, in a San Francisco boarding house talking to spirits. The papers of the 4 women, on the total record, live in the archives. The historic New Orleans collection holds the Myra Clark Gaines papers. The Howard Tilton Memorial Library at Tulane holds the Myra Clark Gaines collection. The San Francisco Probate Court Archive holds the Blythe and Fair contest files. The Federal Court Archives of the Ninth Circuit hold the Sharon versus Hill records. Each of the papers is on paper. Each of the papers has a shelf mark. Each of the papers is in the hand of a librarian or an archivist who can retrieve it on request. The women who wrote them, and the women who produced them in court, and the women who fought for them across decades of American litigation, are not on the shelves. They are in the papers. That, on the final tally, is what the papers were for. Chapter 16. A woman named Myra died in 1885. A woman named Myra died in 1885, 6 years before the ruling in her favor came down, and this is what the fight cost her. She died in New Orleans on the 9th of January 1885 at 79 of pneumonia and lung congestion. The New York Times ran the headline the following morning: Myra Clark Gaines dead. The plucky woman prostrated by pneumonia. She had been the plaintiff for 51 years of her life. She had been married twice and widowed twice. She had spent both husbands' fortunes on the case. She had spent, on the record of her personal finances at her death, most of what she and her 2 husbands had earned. She had spent so many nights in trains between Philadelphia and New Orleans and Washington that the case papers list her residence in some filings as merely of the United States. She had, on the record of her adult life, never held a paying job. She had, on the record of the case, filed suits under her own name from 1852 forward, at a time when American courts still routinely refused to seat women as witnesses. She had died before the ruling in her favor came down. On the 23rd of February 1891, the Supreme Court of the United States, in City of New Orleans versus Whitney, ordered the City of New Orleans to pay her estate $923,788. In 1889, in City of New Orleans versus Christmas, the court had already ordered the city to pay her estate $576,707.92 on a related claim. Her heirs had, at last, prevailed. The heirs did not, on the ledger, receive most of the money. The creditors of the case had filed first. Attorney fees, loans, publication costs, reproductions of depositions, the travel expenses of 57 years of interstate litigation, legal expenses and debts prior to the final decree consumed at least $860,000 of the settlement. The heirs, when the accounting closed, received a small fraction of the original judgment. She had lost the money. She had won the name. The paper she had chased for 51 years was, on the 1858 ruling of the Louisiana Supreme Court, admitted to probate as if the physical paper were in the court's hand. The 1813 will of Daniel Clark, in which he had named her his legitimate daughter and heir, existed on the record. Every court in the country, from 1858 forward, was required to treat that fact as fact. Daniel Clark had named her. The paper had said so. That, at the level of the record, was what the case had been for. The paper of the 20th of August 1880, in Sarah Althea Hill's case, was declared a forgery by every federal court in the United States by the end of the year 1889. The 4 pencil contracts of Nettie R. Craven against the estate of James G. Fair were rejected in the middle 1890s. The 3 claimed marriage lines and the 7 family Bibles of the Blythe case were dismissed by Judge Coffey on the 1st of August 1890. The one paper of the 4 cases that unambiguously prevailed was the paper Florence Blythe never signed and was never even asked to produce, the reconstructed record of Thomas Henry Blythe's letters acknowledging her as his daughter. The one paper that prevailed by admission to probate on reconstructed testimony was the 1813 will of Daniel Clark, the paper Myra Clark Gaines had never seen and had chased her entire adult life. The paper the woman held up in court, in 3 of the 4 cases, did not win. The paper the woman had never held, in the 2 cases that ultimately prevailed on the merits of the paper, did. The paper is what the woman could produce. The paper is not always what she could produce that would work. Coverture had told her she legally did not exist inside a marriage. The executor system had told her she had no standing outside it. The written declaration doctrine of California had told her the paper alone was enough. The federal court had told her the paper alone had to be genuine. She had, in each case, produced the paper and let the court decide. She had, in each case, paid for the decision. Gaines had paid in time, 57 years, 2 dead husbands, a verdict that came down 6 years after her funeral. Blythe had paid in proxies. A childhood in England, while adults fought her war for her over an ocean. Craven had paid in reputation. A professional life in San Francisco reduced to a paragraph in an Iowa death notice. Hill had paid in everything. A husband, dead on a dining room floor with a hole through his heart. A Supreme Court justice 5 feet away at a breakfast table. 45 years locked inside the California asylum at Stockton. The one who had paid the longest in the direct calendar of her life was Myra Clark Gaines. She had been born in 1805. She had discovered her father's name in 1830 at 25. She had filed the first suit in 1834 at 29. She had been widowed in 1837 at 32. She had been remarried in 1839 at 34. She had lectured to packed halls in 1840 at 35. She had won her first victory in Barnes in 1843 at 38. She had won her first Supreme Court victory in Paterson in 1848 at 43. She had been widowed a second time in 1849 at 44. She had lost the reversal in 1852 at 47. She had won the Louisiana Supreme Court's probate of the 1813 will in 1858 at 53. She had won her second Supreme Court victory in 1860 at 55. She had won her third in 1867 at 62. She had continued to file, year after year, into her 70s. She had died in 1885 at 79. Her estate had received the final judgment in 1891, 6 years after her death, 65 years from her father's death to the final judgment, 57 years from her first filing to the ruling. She would have done it again. She would have done every year of it again. There is nothing in the record of her life, in her letters, in her lectures, in her marriages, in the 51 years of case papers she filed with her own hand, that suggests otherwise. She had, in 1830, in a Philadelphia parlor, read her father's handwriting for the first time and had understood who she was. From that moment, on the record, she was the plaintiff. She would have been the plaintiff for as long as she was alive. She was. The button quote, is the one the New York Times ran on the 10th of January 1885, in the obituary of a woman who had died the day before at a small house in New Orleans. The obituary was 2 columns long. The headline was 5 words: "The plucky woman, prostrated by pneumonia." That is what a woman who signs a piece of paper against a rich man and stays in the courtroom for 57 years is called in the American press on the morning after her death. Plucky, prostrated. Not in the newspaper's headline, victorious. Not in the newspaper's headline, vindicated. Plucky, prostrated. And the ruling in her favor, still 6 years away. She was, in the paper that outlived her, in the 51 years of case captions running from W. W. Whitney versus Eleanor O'Byrne et al. Of 1834, through Ex parte Whitney of 1839, through Barnes versus Gaines of 1843, through Patterson versus Gaines of 1848, through Gaines versus Relf and Chew of 1852, through the Louisiana Supreme Court's Succession of Clark of 1856, through Myra Clark Gaines versus Duncan N. Hennon of 1861, through Myra Clark Gaines versus the City of New Orleans of 1868, through Gaines versus Fuentes of 1876, through Davis versus Gaines of 1881, through City of New Orleans versus Christmas of 1889, through City of New Orleans versus Whitney of 1891, the same woman, under 3 surnames, married and widowed twice, named on more Supreme Court dockets than any other private plaintiff of her century, on the last of them, 6 years after her death, the winner. She was the plucky woman, and she was prostrated by pneumonia, and she was the plaintiff. The paper of Daniel Clark's 1813 will, which she had never held, and which had been reconstructed only from the testimony of witnesses who had died decades before the ruling, said her name. It said that she was the legitimate daughter of Daniel Clark. It said that she was his heir. It said what she had spent 51 years in American courtrooms trying to make an American court say aloud. It said her name, and the court said it. And the record of the court holds the paper now in the archives of Louisiana, and in the archives of the Supreme Court of the United States, and in the archives of Tulane University, where any reader who cares to walk into the Howard Tilton Memorial Library on any weekday afternoon can request the papers of the case of the estate of Daniel Clark, and can read them and can see, in the case captions, her name. A woman named Myra died in 1885, 6 years before the ruling in her favor came down. This is what the fight cost her, and this, in the paper that outlived her, is what she won. If tonight's story struck you the way it struck me, I would love it if you would subscribe. And I would love it more if you would tell me in the comments below which of the 4 papers in tonight's video was the one that should have won, and whether you think Sarah Althea Hill was a wife wronged, or a widow the law refused to name. I read every comment. I will see you in the next one.